Hello friends, in the YouTube channel Advocate Amit Kumar Gupta. Today we will discuss a very unique case. The name of the case is Deputy Commissioner of Income Tax, Mrs. Pallavi MISHRA. This matter has been decided by Jaipur ITAT and the case has been reported in 99 ITR at page number 214. The date of the judgment is 14th July 2021. In this case, the concept of protective assessment has been explained. There is no provision in the Income Tax Act to pass an order on the basis of protective assessment. But the judicial precedents has given due acknowledgement to the protective assessment. What is protective assessment? When the department is in a fix that whether an addition is to be made in the hands of A or in the hands of B, then department makes the protective assessment in the hands of the assessee. And when this matter goes to the appellate authorities like CIT appeal and the ITAT, they have the power to decide whether this protective assessment is to be converted into substantive assessment or vice versa. In this particular case, there was a search on a group. Assessee was also a part of that. So the assessment of assessee was done under section 153A, read with the section 143 subsection 3, in which the addition was made in the hands of the assessee under protective assessment regime. The main group on which the search was done went into the settlement commission. The settlement commission passed the order, but the facts were very clear that the assessee was not a part of that the order of the settlement commission, and the assessee has not made any application to the settlement commission for passing that order. But after passing the order, the assessing officer, on the basis of the same facts which were available at the time of making the assessment under section 153A, converted the protective addition into the substantive addition. The assessee was before the CIT appeal for the assessment order which was earlier passed, and the assessee has to go for another appeal against the order in which the protective assessment was converted into substantive addition. CIT appeal gave the relief to the assessee that the assessing officer do not have the jurisdiction to convert the protective assessment into the substantive assessment. The department went into the appeal in the ITAT, and the ITAT said that there was no change in any of the facts, or there was no new information on the file of the assessing officer, and it was a mere change of opinion. And even if there were facts or new information with the assessing officer, the assessing officer should have opted the route of section 154 or section 148 as per the law. But the assessing officer do not have any power to change the order which has been passed earlier. When the assessment order is passed, the assessing officer becomes functions officio, that is, he does not have any power further on that order. So in this particular case, it was decided by the Jaipur ITAT that the assessing officer do not have any power to convert any assessment which has been done on the assessee in the form of protective assessment into substantive assessment or vice versa. The assessing officer loses its power. If he wants to do that, he has the power under other sections, and by following the due procedure of those sections and those provisions of the Income Tax Act, the assessing officer can do that. But in this particular case, only the appellate authorities do have the power to decide whether this addition is a substantive addition or a protective assessment. At the end of this video, once again I am repeating the name of the case, The name of the case is Deputy Commissioner of Income Tax versus Mrs. Pallavi MISHRA. And this matter has been reported in 99 ITR at page number 214. Thank you, friends.